Hi, hello, how are you all? Welcome to my channel Law Made Simple with me Vidya Reddy. Today in the series of labor law episodes, let us learn a new topic, Workmen's Compensation Act 1923. When can a workman get compensation, on what factors? So the object of Workmen's Compensation Act 1923 is to make provisions for the payment of compensation by certain class of employers to their workmen for injury by accident. Under this act, payment of compensation can be made obligatory and all employers to whom the act is applicable. The purpose of this act is to make good the actual losses suffered by the workman or his dependents. Section 3 of the Act provides conditions where the employer can be made liable to pay compensation. So let us look into the employer's liability. According to Section 3 Clause 1 of the Workmen's Compensation Act, an employer is liable to pay compensation to a workman if the following conditions are satisfied. What are the conditions? Personal injury must have been caused to a workman, and such injury must have been caused by an accident. Such accident must have arisen out of or in the course of the employment, and the injury must have resulted in the death of the workman or in his total disablement for a period exceeding 3 days. Let us look into what is personal injury, accident arising out of and arising during the course of employment. Personal injury. Injury ordinarily refers to bodily injury. However, personal injury is also wide enough to include a nervous shock, a mental injury, or a strain. When we look into the case law of Indian News Chronicle versus Mrs. Louis Lazarus, the court held that the injury caused by an accident is not confined to physical injury only, and even pneumonia caused by the nature of work also amounts to personal injury. So under this act, personal injury means damage done to the workman by some accident. So what is this accident? The second requisite to make the employer liable under this act is that such personal injury should have been caused by way of accident. The term accident has not been defined under this Workmen's Compensation Act, but accident generally means an unexpected, unwanted, and unavoidable mishap. If a person becomes insane as a result of an accident and then commits suicide, the death is the direct result of an accident. Let us look into how arising out of and in the course of employment also becomes part of the accident. The third requisite to be satisfied for making the employer liable under Section 3 of the Act is that the personal injury should have been caused by an accident arising out of and in the course of employment. This phrase has got a lot of litigation. It is said that the phrase arising out of and in the course of employment is deceptively simple but litigiously prolific. Grammatically speaking, arising out of and in the course of employment both must be construed together to make the employer liable. So let us look arising out of cases. Arising out of refers to the reason for the accident. There must be a causal connection between the nature of the employment and the accident that occurred. The injury must have resulted from the inherent risk involved in the nature of employment, and this includes incidental risk. To fulfill arising out of, the workman should be discharging his duties assigned to him by the employer. The concept of arising out of has been liberally interpreted by the courts so as to enable the workman to get compensation. In the case of Trustees Port of Bombay versus Yamunabai, there was a carpenter who was discharging his duties in the workplace. Someone threw a bomb into that premises. As a result of that bomb explosion, the carpenter was injured and he was succumbed to injuries. The question before the court was whether the injury was arising out of. If we take grammatical interpretation, the injury has not resulted by arising out of because there is no causal connection between the nature of employment and the accident. However, the court has taken the liberal interpretation and held that at the time of accident, that is bomb explosion, why the worker was there in that premises, and the answer is because of his employment. The court held that arising out of has been satisfied in this case. In another case of R.B. Mundra and Company versus Mr. Bhanwari, when the deceased was discharging an incidental duty, there was an injury and the court held that employer is liable to pay compensation. So, in the course of employment, it refers to the time and place of the employment. Generally, employment commences where the workman reaches his place of work and ceases when he leaves the premises. During this period, if accident takes place and causes injury to the workman, it is said in the course of employment is been satisfied by liberal interpretation. The courts have held that taking meal, drinking tea are also part of course of employment. Let us look into another case where the employer was liable. In the director DNK project versus Srimati Buchitalli, in this case, the deceased has done a strenuous work. The deceased has come out of the factory and collapsed there itself. It was found that the death was due to his strenuous work that the workman undertook that day. In this case, the court held that arising out of is fulfilled and further held that in the course of can be inferred from this case. Let us look into what is doctrine of notional extension. Ordinarily, man's employment doesn't begin until he reaches the place where he has to work. The period of going to or returning from employment are generally excluded and not within the course of employment. The courts in some cases felt that there may be reasonable extension of time and place of employment. The workman may be regarded as in the course of employment even though he had not reached or he had left his employer's premises. This is known as deemed extension of employment or doctrine of notional extension. We have certain case laws. Saurashtra Salt Manufacturing Company versus Baiwalu Raja. In this case, what happens is there are two ways to go to the salt manufacturing company, either through ferry or through an overroad. So overroad takes 6 to 7 miles to reach the manufacturing company. So some of the workers took the ferry route, and because of the higher tides, the boat was filled or the people got drowned in the water. So the court has rejected to apply this doctrine because there was another route the workman can take. So when doctrine of notional extension was pleaded before the court in this case, the court rejected to apply this doctrine. However, the court applied the same doctrine in the case of General Manager Best Undertaking Bombay versus Mrs. Agnes. Best Undertaking Company General Manager. Best Undertaking is nothing but Bombay Electrical Support and Transport. Here what happened is, here the employer named P. Nanu, he was a bus driver employed in the same corporation. So one day Nanu Raman, he finished his work for that day and at Jogeshwari bus depot. After leaving that bus depot, he boarded another bus in order to go to his residence. So the bus he boarded in collided with the stationary lorry parked at some point. So as a result of that collision, Nanu Raman was thrown out on the road and he got injured. He was taken to the hospital for treatment, but he ultimately lost his life. What the court has held in this case is, Nanu Raman's widow has filed an application claiming for some amount of compensation through Workmen's Compensation Act. So the general manager of the Best Undertaking Bombay, he contended that accident did not arise out of or during the course of employment or in the course of employment. So, the High Court of Bombay held that the said accident arose out of and in the course of employment of the deceased.